Hi, I'm Bob WARACH, and we're doing another segment of Dockets. Today we're going to discuss Medicaid, a relatively complicated law that affects many people in our community. Medicaid provides a number of programs, but we don't have the time to discuss them all today. What we will do is discuss the two most common types of Medicaid, and to do this, I have two lawyers as my guests. They're both very knowledgeable about Medicaid laws and how they apply on a practical level. They will address the most frequently asked questions about Medicaid and make what is a very complex set of laws understandable to both you and me. So let me introduce my guests now. We have Jennifer Coulter, who works in town with the firm Townsend Allala Coulter Kludt, and we have Magda Soto, who you may have seen before, as she is my partner in WARACH, SOTO Associates. I do want to stress, though, to everybody listening today, that we are not giving legal advice. We are giving an overview of Medicaid as best we can in this limited amount of time. And I'm going to start with Jen. So Jen, a lot of people don't realize that Medicaid is basically kind of a basket of laws. Is that correct?
It is. We talk about Medicaid as though it's one thing, but in Texas alone, we've got between 43 and 45 different programs that we call Medicaid. And they do a host of different things, from helping to pay a Medicare premium, to working as health insurance, to providing home care for people who need it.
And when you talk to your clients, you have to know how they would qualify for these various programs. Is that correct?
Absolutely.
What are the two, I'm going to hop over to Magda for a minute. What are the two most common types of Medicaid that you think affect people in our community?
So I think usually when people start thinking about Medicaid services and what things they need, it's usually long-term Medicaid, SSI, and that's usually triggered by a loved one needs some sort of long-term care in a nursing facility, but that's usually what gets people thinking about Medicaid.
What is SSI?
So SSI is, of course, income. So anything that's going to qualify for...
You said income?
Income.
Okay.
So, of course, anything that's going to help them. So if we have anybody with any sort of special needs, do they qualify for that supplemental income?
Medicaid requires, the SSI requires both an income and an asset limit. Is that right?
Correct.
Okay, Jen, what are those?
Actually, all Medicaid programs like this are going to have both an income and asset limit. For SSI, the maximum income limit the person can have per month is $771. There are some disregards, but that's the general number for 2019. The resource limit for a single person is going to be $2,000. For a married couple, $3,000.
Okay, now go back a minute. You're saying that, I didn't understand the $700 one.
So if I'm a disabled person and I have $700 a month in monthly income and under $2,000 in resources, I may qualify for SSI, and it can get me another $71 a month in income, but more importantly, it will get me Medicaid benefits that I use as regular health insurance, the same way a person who has Medicare uses it, or a person who has Blue Cross Blue Shield uses it to pay for doctors and hospital visits.
All right, and then you were talking about, then you went to the next step. A single person can earn what?
So a single person can have that $771 a month in monthly income,
okay,
before they're ineligible. And then they can have $2,000 in resources.
Okay, and a married couple?
A married couple is going to have a higher limit, more than $1,000 a month for a married couple, and more than $3,000 for resources.
In the bank?
Yes.
And is that on a monthly basis?
Resource determinations are done as of the first moment of the calendar month for the entire month. So if on May 1 you have $3,001 as a married couple, ineligible for the entire month of May. If you have $2,999 and all other eligibility requirements are met, eligible for the whole month of May.
Okay, and again, we're talking about SSI, correct?
Mm-hmm.
Correct.
So what's the deal now with the long term? I know I said it was self-defining basically, but now define it for me.
So normally when we're talking about long-term Medicaid, and I would say that's usually with elder population, or we have a loved one who unfortunately they got diagnosed with dementia, Alzheimer's, and that's where we really start thinking about it. I now need this individual to go into a nursing facility. I don't have the resources to private pay, so how can I get onto Medicaid so that Medicaid can pay for that long-term care facility?
And how do you do that?
So of course you're going to look at income. Do I qualify for income? Do I qualify resource?
Is the income the same and the resource the same as what Jen just talked about, or is it different?
It's different. Well, actually,
Go
so
on.
It's different.
yes.
In what regard?
Would you like to take that?
You can go ahead.
Sure. So for income, we're going to look at the person's income is if you have under $2,313 a month in monthly income this year, you can be eligible for it. If you have over $2,313, it's still possible, but you've got to take another step we don't probably have time to talk about called a qualified income trust or Miller's trust.
Okay, we can save that for another program.
Sure.
But and you're bringing up a good point, is how complicated this basket is and how the certain things work together. But I want to go back again to this long-term care for a minute. There are exceptions, correct, to, well, I guess I'm jumping the gun. One of the difficulties in that people are reticent to get Medicaid is they always hear that the government can come and take your house. Is that right?
I think that is unfortunately the biggest misconception, hesitation, is people talk and they're fearful. They took my neighbor's house and I don't want to get onto long-term Medicaid because I understand the government's going to take my house, which is completely untrue. And I know we're talking about different things to protect, and of course the biggest thing is people don't realize there's a ladybird deed which will protect your house, and you can still get long-term Medicaid. And of course, by protecting your asset, your house that you worked very hard for, when something does happen, they cannot come back against that resource.
Okay, so let's take a few steps back again, because we have to go slower for me. The program that people are fearful of is, it has the acronym MERP, M-E-R-P, which is the Medicaid Estate Recovery Program. Is that right?
Yes, sir.
Okay. How does that work, Jen?
So the Medicaid Estate Recovery Program, MERP, can make claims against the probate estates of certain people who receive benefits, long-term care benefits, after they're age 55. Probate estate is sort of the important phrase there, and most people don't understand it. I wouldn't if I weren't a probate attorney. So probate estate are those assets we have to take your will to the court to transfer title on. For most people in Texas, when you pass away, that's going to be your house. And so most people think MERP takes your house because for most people, the house is the probate asset.
Okay, so, and I think you explained that very well in terms of what is a probate asset. A probate asset is an asset that can only be transferred through a process in court, correct? Mm-hmm. What's a non-probate asset, Magda?
So non-probate asset is anything that would have a beneficiary, kind of like a bank account. So if you have a beneficiary in that bank account, when you pass, that bank account is going to go to the designated beneficiary. We have now taken that asset out of probate, kind of like with the house we talked about, the ladybird deed.
All right, let's stick with that then.
Okay.
So now we have a house, and we don't want it to be a probate asset. We don't want to have to go to court to transfer it. Correct? That's one thing. The other thing is MERP can only file a claim against an asset that is in the probate estate, right?
Correct.
So now talk about the ladybird deed.
So with the ladybird deed, you're making it very much similar to the bank account, which is the transfer does not take effect until that person passes away. So the individual who is trying to qualify for Medicaid, that house remains in their name. And of course, this deed says that upon their passing, that house automatically transfers to the loved one. So we have now made that asset a non-probate asset.
Which MERP can't get a hold of.
Correct. Since it is non-probate, they cannot attach to it because, again, we've taken out of the equation.
Okay. Now there's something else I'd like you all to explain. I don't care which one of you does it, but it's my understanding that if a husband and wife are both getting Medicaid, on the death of the first spouse to die, Medicaid does not make a claim against that estate. Is that correct?
Absolutely. There are a number of exemptions to recovery by MERP. If you have a surviving spouse, the claim goes away, period. If you have an adult disabled child who's disabled as the Social Security Administration defines it, the claim goes away entirely. If you have a child under 21, the claim goes away. If you have an adult unmarried child living in the home, the claim goes away. So there's a lot of ways to get around it, even without doing the ladybird deed, but the ladybird deed is the safest, cheapest way because we can't always be sure which spouse will survive. And if both spouses are getting Medicaid, there will be a claim at the end of the life of the second spouse to pass away.
And when we as lawyers go to court, we have to prove to the court that the person who has passed was not receiving, was or was not receiving Medicaid, and the court will then direct us in one direction or the other, correct?
Correct.
All right. Now, let's stick with the ladybird deed for a second. That's beneficial even if you're not involved in a Medicaid situation, correct?
Correct. As probate lawyers, I also hear it called, I don't mean offense for that, but it's a poor man's will or a poor man's transfer, because if really the only asset I have is my house and bank accounts, this is a very easy way to make sure that my asset is going to pass to my loved one. That way there's no added expense of probate. I know people are fearful of probate and the expense. This is a very easy transfer, making, in essence, the big asset, the house, transferable when you pass.
And the other issue with it, just so everyone is straight, you retain title until you die.
Correct. And that's a big thing, because I think, unfortunately, people want to give it to their children right away. And, of course, this is when we're not trying to get services. Well, you want to make sure you're protected. And, of course, taxes, none of that goes up because title stays in your name until you pass.
You retain the over 65 exemption. You retain the homestead exemption, because the actual transfer of title doesn't occur until their death, right?
Correct.
So it works in a number of ways. I think, again, just talking about probate for a minute, when we put on our probate hats, and we're not talking about only Medicaid, what we have to really, because people, and this makes sense, people come into your office, they're afraid of the money they're going to have to spend anyway with a lawyer. So when you give them an option of doing something that is conceivably less expensive than going through probate, they're going to want to jump at it. But they have to understand that if they do a ladybird deed, but then they have other assets that have to be transferred through a will, they haven't done themselves any favors, because they're going to have to go to court anyway. So basically, at that point, they're double spending their money. So I really, well, I know you do too, we really hammered home, if you're only talking about the house, or if you've turned all of your assets into non-probate assets, then you're okay with doing that. Let's just spend a minute, again, taking a little veer away from Medicaid for a second. Let's spend a minute with how you would turn assets into non-probate assets. Jen, I'll give that to you.
Certainly. Well, for your financial accounts, your bank accounts and things like that, you go down to the bank and you ask for either a right of survivorship if you have a co-owner on the account. So my husband and I have an account together. We can have a right of survivorship, which means he will take ownership when I pass away automatically, or I will take ownership when he passes away automatically. Or you can set up a pay-on-death beneficiary designation. You designate who you want your assets to go to automatically on your death. For your vehicles, the DMV has a form out, a transfer on death instrument, and you can designate who you want your vehicle to go to after you pass away. Those rights of survivorship agreements, the pay on death beneficiary designations, and the transfer on death instruments, those are the three things that people usually do, and most financial institutions have, so that you can make sure that your assets are passing outside of the probate process.
And you wouldn't have to go and down to the court and stand in front of a judge
No.
and have the assets passed that way, correct?
Yes. And certainly, anytime we can keep the court and lawyers out of your life, it's going to make your process much cheaper for you as well.
Personally, I want to be in their lives.
But for most of my people, that's something we're looking for because we're trying to avoid the Medicaid estate recovery program.
Absolutely.
If it applies to the kind of benefits they're receiving.
Let me ask you another question, since we're talking so much about the Lady Bird deed, both for Medicaid purposes and for practical purposes. Are there restrictions on it? Like, can you do a Lady Bird deed if the house you're living in has a mortgage on it?
So as long as you are passing it down to a descendant, you're okay. So meaning that if you're passing it down to your daughter, your son, as far as any restrictions, I always say be careful if people want to pass it down to 7 different children, and that can get very complicated if you are now asking that 7 people be entitled when you pass.
So if there's a mortgage, it can be lineal.
Yes.
If there's a mortgage, can it go to anyone other than a lineal descendant?
No, it cannot.
Okay.
There is another instrument we can use to transfer it on death that will allow it to go outside of the direct lineal descendants. And so if you want to transfer it to someone other than your spouse or your lineal descendants and you've got a mortgage, there's another way to do it, though.
Which is what?
It's called a transfer on death deed, and it's a statutory creation, and it'll let you do that.
What's the difference between the two?
So the big difference between the two is the transfer on death deed, it can still open itself up to creditors. So when you pass, the creditors can actually go after your estate. With the Lady Bird deed, it doesn't open itself up to creditors. So that's a big difference between the two.
Okay. Now let's get back to Medicaid again. What's the biggest difficulty that you find your clients face when applying for Medicaid?
I think there's sort of 2 major difficulties that my people face. One is that they simply don't know what they own and how to describe it. So a lot of times I will see people who will look at the application and fill it out incorrectly and miss assets that they own. They won't list a life insurance policy or a business or something on that application, either because they don't understand the application or because they don't necessarily know that they have that asset. And that can be a major problem. And then the second is...
In what regard?
Well, if you don't list it, you may be inappropriately getting benefits. If the state decides that you did it on purpose, it can be Medicaid fraud, and that is a criminal offense. And so we'll see people who say things like, well, I didn't realize that I had to list this account I put in my daughter's name for her education as one of the accounts. And that can then result in a conviction for Medicaid fraud and the loss of benefits and the requirement that they be paid back whatever they received inappropriately. So that is an issue.
Would the loss of benefits be permanent?
No, not necessarily. Once you've gone back and fixed the problem and repaid the benefits that you inappropriately received, they can come back and get those benefits back. But it can be a long delay, and it can be a major problem, to speak nothing of the criminal offense.
Okay, well, I'm going to let's assume for a minute that your people have not done it consciously.
No.
So there's not a criminal issue here. Is it easy to fill out the form?
To me?
No, not to you. I'm not asking you or Magda if it's easy. I'm asking, is it difficult for your client? I mean, a lot of people who apply for Medicaid don't have a lot of resources to begin with. So if it's not a user-friendly form, it could be a real issue.
Honestly, I don't think it's a terribly user-friendly form. And there's multiple different forms depending on what you're applying for. But I personally don't think it's a terribly user-friendly form, but if your property is fairly simple, you have a house, a car, and one bank account, then usually it's fairly simple to do. If you've got anything more complicated, it can be a little difficult to fill out.
Magda, what do you tell people when they come in to the office and they say they want to apply for Medicaid and would you help me out? And by the way, I just gave my homestead to my son.
Which happens, unfortunately, more often because their neighbor told them to do that. There's a lot of neighbors out there. And unfortunately—
Giving legal advice.
Yes, yes. And at that point, we have to undo it because, of course, the biggest thing is do not transfer your house. Your house is not going to keep you from getting these services. So now we have to deed the house back to you and then protect the house. But unfortunately, at that point, it's double the work. So just because you gave your house away is not going to protect it, because at that point, as soon as you transfer your house, it is looked at as cash value for Medicaid. So you just gave an exempt resource away, so we have to undo it so that you can now qualify for Medicaid.
So people have to understand that their homestead is exempt, is an exempt asset when they go to qualify to Medicaid, for Medicaid. Is that correct?
Correct. And I think that is very hard for people to understand because they think that I have to do something with that house. And it's like, yes, we have to do it to protect it, but don't give it away.
And how hard is it to undo it?
So it's not terrible, but of course it's an extra step. We now have to deed the property back to you and then do a ladybird deed. So that's an added step that we probably should not have had to have done in the first place.
But how does Medicaid look at the fact that you have made this transfer?
So if you haven't applied yet, that's where you have to undo it. You're in the process.
I don't mean to be dense. I am the one who's being dense here. But okay, you go, Jen.
So when you make a gift, I tell my clients, gift is a 4-letter word. Don't use it.
Okay.
Because whenever you make a gift and you're hoping to get Medicaid benefits, the state of Texas and the Social Security Administration, if you're applying for SSI, are going to treat it as something that you should be penalized for. They say if you have enough money to be giving stuff away, you should be paying for your own care. And we will not pay for your care until the amount that you gave away would have been used if you'd used it for yourself.
Which is the value of the house.
So if your house is worth $77,000 and you're applying for SSI, then they're going to trigger a 100-month penalty period. So 100 months during which you are otherwise eligible, you don't have money or resources to take care of yourself, but during which they won't pay for it. So you've taken this asset that didn't count against your $2,000 resource limit, that was the largest thing we can protect for you, and you've turned it into a penalty period.
Okay, but let me go back now, because I don't quite get this. I transfer my house to my son, of which I don't have. And now I go to the lawyer, and the lawyer said, oh my God, that's wrong. You shouldn't have done that. We have to put it back in your name. Is there a penalty for that initial transfer? Even maybe he had it for a week.
So when you give back the transferred asset, when someone gives back the transferred asset, it always wipes out the penalty. So if the son gives back the house, and this is where we do face some problems because sometimes the son says, I'm not giving back the house. Right. But if the son gives back the house, then the penalty is totally wiped out. It's a little different if what you gave away is cash, but in general, the penalty wipes out if you give it back. And that's
no matter how long it's been in the other person's name.
Yes.
Wow.
As long as if you give it back before the Medicaid application, before the receipt of benefits, if you give it back after you've started getting benefits, you give it away during benefits and you trigger a penalty, then giving it back will treat it as though you always had that asset. So it may make you ineligible for the back period if it bumps you over the resource limit. But if it's the house, it's always going to wipe out the penalty because that's your exempt house.
Okay. I think I understand.
Gifts are bad is the short version of that,
yes.
Always.
And I think just to piggyback off of that, because sometimes we had $20,000 and I gave $2,000 to each child. Why was that bad? Well, are they going to give it back? Well, they've already spent it. So now you really trigger that penalty because they just thought I would give it away instead of actually private paying. So sometimes we have a little bit of money that we should have never given away, and the children don't have the money, and you are now ineligible for that time period, and you have to private pay, especially when we're talking about liquid assets, which happens unfortunately more often than not.
Let's kind of recap here, because we have about 5 minutes left. I want to do a quick recap. And so gift is a 4-letter word. Cash is a 4-letter word. Never give away your homestead. It's an exempt asset. MERP cannot take, even if you don't do a ladybird deed, MERP cannot take your house. They can only make a claim on it for the amount that Medicaid paid to help you out. They pass by, if both parties are on Medicaid, both husband and wife, they wipe out the debt of the first to die. And you better talk to a lawyer about all this before you get into a mess. Is that a pretty good recap?
I think that's about the size of it.
Okay, so now quickly, and maybe we can do another program on this, I'd like you both to just kind of talk briefly about what people hear about as Medicaid trusts or Miller trusts or whatever trust you want to talk about that help people with Medicaid.
So I think a Miller Trust is a great thing. So of course we talked income, and sometimes unfortunately people are over income by $50.
So explain this to me a little slower.
Sure. I'm qualifying for Medicaid, but unfortunately I'm over income wise. So we talk about a Miller Trust. What can I do with my income, which is keeping me from qualifying? And again, the big key with Miller Trust, because I hear different things, is can I put all my resources in there? And it's no, it's just income. Because again, I'm over, my name is on that check and my income is over, and it's keeping me from qualifying. So we can create an income trust, also known as a Miller Trust, that is going to divert that income. So now, because it's diverted into that trust, I can qualify for Medicaid long-term care.
And how can you use that income in the trust?
So if there is a spouse, of course, spouse will be entitled to money from there. If there's not, then of course that money is utilized for that individual and is really used to pay for that facility. And of course they'll get their income, their allowance on a monthly basis. It's a minimal allowance, but it's really a way to divert that income so I do qualify for long-term Medicaid, so that Medicaid is paying for the facility that I'm in.
And where does that money go when that person dies?
It goes back to pay whatever the state pays.
Okay, so it doesn't stay in your estate and go to your heirs?
No.
Okay.
Only if there's money left over.
Is there another type of trust, Jen?
Yes, there are special needs trusts. These can be set up either by a third party with a third party's money, or by the disabled person with his or her own money if they're under 65. And they can be used to shelter assets from counting towards that $2,000 resource limit. So if I'm a disabled person and I receive $10,000 from an inheritance, that $10,000 will put me over my resource limit. But I can create a self-settled special needs trust and put the money into that, and then I can be able to protect it against my $2,000 resource limit if I'm under 65 when I receive it.
So, and the other thing is, we only have a minute left now, so I'm going to kind of wind this up. But I'm always very conscious of telling my clients kind of exactly what you just explained. If you have a disabled person that you intend to leave money to, do not leave it to them in the will. And don't die intestate, or they will just inherit it, because that will kick them out of the benefits. So I want to thank you both for coming. I know there is a whole lot more we can talk about, and I think maybe one day we'll do it. You'll come back and we'll visit again on this issue that's complicated, but I think we made it pretty understandable. If it's understandable for me, I think most people will understand it. Thank you very much for coming today.
Thank you
for having us.
Okay.